I'm Youkang Ko. I'm a professor at Seoul National University Law School, South Korea. And before joining the faculty, I had worked as a judge for Korean courts during 7 years. It is an honor to be given the opportunity to present at the inaugural CODIFI conference. Today, my brief presentation will cover a particular issue regarding virtual assets, which is the enforceability of virtual assets in terms of civil execution. As I have a limited time frame given, this session will be a high-level overview covering the current legal status and related discussions instead of diving deep into the details, which can be overly technical. So while recently prices in the cryptocurrency markets are sliding and some people call it's only the beginning of the crypto winter, it is undeniable that still an immense amount of value is at stake in the form of diverse types of cryptocurrencies. According to a report issued last year by the Korean Financial Intelligence Unit, 5.5 million people living in Korea, which accounts for more than 10% of the nation's entire population, are holding at least some type of cryptocurrency, may the amount be trivial. Also, recently, in a criminal case, the Korean Supreme Court acknowledged that cryptocurrency can be regarded as an intangible asset that has certain economic value. Thus, criminal profits received in cryptocurrency can be subject to confiscation by the government. Not surprisingly, creditors in Korea have begun targeting the debtors' crypto assets in attempts to collect their debts. Here enters the issue of enforceability. In other words, whether a creditor can compulsively seize virtual assets, such as cryptocurrency, from the debtor and sell them for their satisfaction. First of all, regarding terminology, how is virtual asset defined in Korea? A newly enacted legislation named Specified Financial Transaction Information Act defines virtual asset as an electronic token with economic value that is tradable or transferable electronically. However, the primary purpose of this Financial Transaction Information Act is to provide a regulatory scheme to prevent money laundering and funding terrorism, not to define whether those assets are subject to execution when the creditor had already obtained a judgment. Those matters are governed by the Civil Act and the Civil Execution Act. In order to qualify as an executable asset that can be subject to civil execution, an asset must be an immovable or a corporeal movable or a claim, or at least fit into the category of other property rights, which is a catch-all clause. Each category of executable assets has its own procedure of execution and satisfaction, so determining which pigeonhole virtual assets should go into would be the first step to finding the applicable execution procedures. It is quite obvious that virtual assets cannot be regarded as being immovables or corporeal movables. Neither could the assets themselves be classified as executable claims, since virtual assets are not monetary claims, nor do they require the transfer or delivery of securities or corporeal things. As a last resort, then, could virtual assets be deemed as other property rights? Until now, this category has been heavily utilized for intellectual property rights. If we examine virtual assets, they have certain economic value. They are actively traded in the market. So I would say, yes, they can fit into this category. Accordingly, civil execution against virtual assets may be possible following the requirements and procedures of execution pursuant to the category of other property rights. Of course, there are some important caveats we should be aware of. While the wide scope of other property rights allows us to easily mark virtual assets as executable assets, it doesn't necessarily guarantee that compulsory execution will be successful. Partly that is because the legislators of the Civil Execution Act could not have considered the advanced and technical characteristics of virtual assets. One foremost limitation is that in many cases, the creditor may not have any information whatsoever regarding whether its debtor holds virtual assets. And even if the debtor is proven to have some, which kind, how much, and where is the debtor keeping them? Korean courts may issue an asset declaration order to demand a debtor declare its list of valuable assets, but it is still debated that whether the debtor must also disclose its virtual assets. Even in cases where the creditor knows that the debtor has a certain type of virtual assets, many obstacles still exist. The execution of assets generally consists of 3 steps: seizure, encashment, then distribution. Seizure prohibits the disposition of virtual assets. The problem is, under the Korean legislation, for the court to issue a seizure of other property rights, a third-party debtor, which is usually a debtor's debtor, is required. If the virtual asset happens to be held by one of the major crypto exchanges, the exchange itself would be the third-party debtor, since the debtor usually has a claim of reimbursement towards the exchange. There have been actual cases where the Korean court issued preemptive seizure orders listing crypto exchanges as third-party debtors. However, in cases where the debtor holds the virtual assets in its private crypto wallet, there are no clear legal grounds to seize that virtual asset. Even if the seizure were possible, there does not exist effective means to force the extraction or revelation of the debtor's private key. The court may impose some monetary penalties against the debtor to compel the disclosure, but cannot enforce the transfer of virtual assets against the debtor's will by technical means. If the debtor insists not to comply or just say they lost their private keys. Also, the encashment process should involve a lot of problems when it comes to actual practice. Simple but critical questions such as in which market, at which price, and at which time the sale of virtual assets will be performed remain unclear. Highly fluctuating prices of virtual assets add more to the complexity. The recent amendment of the Korean National Tax Collection Act gives us some guidance regarding the interpretation of the civil execution laws. The new Tax Collection Act enabled tax authorities to seize crypto assets held by tax dodgers, even when their cryptocurrencies are stored in personal digital wallets. It also sets legal grounds on which tax authorities can search tax dodgers' premises, force the exchange to transfer the virtual assets to an account designated by the superintendent of taxes, and sell those seized assets, then keep the sales proceeds to be further collected by the tax authorities. However, many question the actual effectiveness of the measure set out in the new act, especially in cases where the tax dodger refuses to reveal its private key or where the virtual assets are stored in foreign crypto exchanges outside of Korea. To wrap up, I would like to stress that the enforceability of a virtual asset plays a key role. It can facilitate trading by ensuring that the title of a virtual asset can be relocated to the rightful owner and enable the possibility to provide virtual assets as collateral. Embracing technological advancements could also help. For instance, smart contracts are advertised to have a capacity to fulfill self-execution by design. Unfortunately, at the moment, smart contracts are mostly used only to the extent of executing the performance rather than in the remedy process. Furthermore, it is a little bit unrealistic to forecast and code in beforehand every possible situation that can trigger an automatic execution. We have to admit that traditional laws and rules of civil execution in Korea have some defects or loopholes in the looming era of virtual assets. Further discussion and legislative amendments would be required for a clear definition of virtual assets, along with effective and practical means of execution against virtual assets. Thank you for your time and attention. I wish to meet you in person next time.